Hi, I'm Kimberlee Stafford, a partner in the Tonkon Torp Real Estate and Land Use Practice Group. Today, I'm going to talk about an important part of every real estate purchase and sale transaction, loan transaction, and some long-term lease transactions, title insurance. Title insurance ensures that title to real property is vested in a certain party, subject only to the encumbrances, covenants, conditions, and restrictions set forth in the title report. In purchase and sale transactions, the seller typically buys an owner's policy of title insurance for the buyer, ensuring the buyer as the owner of the property as a line of first defense against any warranties of title the seller provides in the deed at closing. In a loan transaction, the borrower pays for a lender's policy of title insurance, ensuring the borrower as owner of the property and the lender's mortgage or deed of trust is in a senior position against other liens. I've been using the word owner, but please note that title insurance policies can insure the owner of fee title, or you can get a leasehold title insurance policy for a long-term leases. And lenders can get lender policies insuring their borrower as a tenant under a long-term lease. Title policies can be either standard coverage, which include a list of exceptions from coverage for items that the title company cannot readily ascertain from the public records, such as encroachments that can only be determined from a survey, construction liens which have attached but haven't been recorded, or interests of parties in possession such as tenants under unrecorded leases. Extended coverage eliminates these exceptions but requires an affidavit and indemnity from the seller for factual matters covering the standard exceptions, payment of an additional premium, and a survey if you want to remove the survey exception. Before buying real property or entering into a long-term lease, such as a ground lease, it is standard for the prospective buyer or tenant to review the condition of title as part of its due diligence process. A lender will also conduct a thorough title review before agreeing to close any loan that will be secured by real estate. When the title company issues its title commitment or title report, it should provide copies of all the recorded exception documents. The first thing to review in the title report is the current vesting and legal description on Schedule A of the report. For vesting, you want to make sure that the party listed as owner is the same as the party the buyer has entered into the purchase and sale agreement with, or will be signing the lease with. For the legal description, you want to make sure that all parcels subject to the transaction are listed and they describe the subject property. In some instances, this may be difficult to verify without obtaining a survey. Next, the exceptions to title listed on Schedule B of the title report should be carefully reviewed for 1, liens and encumbrances such as tax liens, judgment liens, construction liens, and mortgages and trust deeds. 2, easements and other third-party access rights. 3, any rights of third parties to occupy all or any portion of the property. And 4, restrictive covenants that would inhibit the buyer's use and enjoyment of the property. Liens and encumbrances need to be paid off at closing with the proceeds from the purchase price. And the buyer will usually want to obtain a survey to verify the location of any easements to make sure they don't interfere with the use of property. And they will want to understand each party's rights and obligations, including with respect to maintenance. Additionally, a buyer may want the seller to obtain estoppel certificates from the holder of the easement rights to confirm there are no defaults or outstanding money owed for maintenance. And of course, the buyer will want to confirm legal access to and from the subject property. Depending upon the nature of the use, third-party possession rights may or may not be a problem. If the buyer is buying the property as an investment with the expectation that it is being leased to others, that is one thing. But if the buyer is expecting to have exclusive possession, that is another. Rights of first refusal, purchase options, and other third-party purchase rights are especially problematic and should be deal breakers unless the seller can show evidence that such rights have been terminated or waived, and the title company agrees to remove them as exceptions to the title policy. Restrictive covenants also may or may not be problematic. It depends on what the intended use of the property is and whether the restrictions interfere with that use. Depending upon the age of the restriction and the number of parties who benefit from it, it could be difficult or impossible for a seller to negotiate terminations of such covenants. In addition to standard policies, title insurance companies also provide a variety of endorsements, which may insure over certain exceptions or otherwise provide additional coverage. The availability of endorsements varies from state to state and upon whether a policy is an owner's policy or a lender's policy. Some examples of common endorsements are: 1, the survey endorsement. If you obtain an ALTA survey, you may purchase an endorsement that ensures the property is the same as shown on the survey. 2, the contiguity endorsement, which ensures that for property consisting of multiple parcels, there are no gaps between the parcels. And 3, the zoning endorsement, which ensures that the zoning designation of the property and gives peace of mind as to what uses are permitted. There are many other endorsements, but unfortunately we don't have time to go into them in this video. This has just been a brief overview of important concerns related to title insurance. It's a vital part of real estate transactions and should not be overlooked. If you have further questions, please reach out to any one of us in the real estate and land use practice groups at Tonkon Torp or visit us at tonkon.com.